We are here at our staff development program in the UWI Mona campus Library Open Week, and the presentation today will be on calling all authors, aspiring authors, understanding your rights and benefits with JAMCOPY. It is my pleasure to host you today. I welcome the Deputy Campus Librarian, Mrs. Jessica Lewis Marshall, other members of the Mona Library team, in-house at the multifunctional room at the UWI Mona Library, presenter, Ms. Philippa Davies, and accompanying team member from JAMCOPY, Ms. Jamila Kasima, members of the Mona Informatics team. Thank you. At this time, we will call on Mrs. Lewis Marshall to give the opening remarks.
Good morning, colleagues, and good morning to our viewers on MonaMedia. My remarks this morning will be quite short, but JAMCOPY has been a wonderful partner in upholding copyright as regards to usage of our collections. But today we want to look at what are the rights of the author, what are the benefits that come through this partnership as well. I know that JAMCOPY has been running a series of sessions online, but we're very happy to have them here with us in person today. And I will hand over with that.
Thank you very much. Colleagues, those who are online, we appreciate your attendance online. This certainly is a very important session as we look at copyright and how we can benefit economically as well as identify those moral rights from which we can also benefit professionally. It is important for us to have such a session. It is very timely because at this time, just last year, 2023, the Parliament passed the Copyright Amendment Act, and it also passed a Copyright Amendment Number 2 Act, which solidifies the place of JAMCOPY in terms of being a licensing agency to collect licenses from organizations for the use of copyrighted works. It is important also because at that time, round about that time, we had two important cases which tested those two pieces of legislation. A case was KFC against versus I think it was KFC, Restaurants of Jamaica versus JCAP, and it tested the veracity of JCAP being a licensing agency authorized to collect royalties. It was further tested by Horizon Entertainment Limited against JCAP once more. And of course, arguments were presented about whether JCAP has the authority to collect these licensing fees and what schedule, which suggests that there may or may not be a lacuna in the law. And so it is important to have this presentation today to say whether these rights, these responsibilities, and benefits are firmly rooted in terms of JAMCOPY being authorized by law as a licensing agency. So at this time, I'm going to introduce, and I was told that I must be brief, so that's my brief. To introduce Ms. Philippa Davis, is a legal and operations consultant at the Jamaica Copyright Licensing Agency, JAMCOPY. She's a graduate of the Norman Manley Law School, and most certainly, she is an author herself. Welcome, Ms. Philippa Davis.
Thank you very much, Mr. Tech, gentlemen. And thank you very much for the warm welcome, Ms. Douglas and Mrs. Lewis Marshall, and to everyone in the room. Thank you so much for the opportunity to share with you again about this very important area of copyright, because it really is the legal basis for what you do, the handling of books and the rights in books. So really appreciate it. And after I make my presentation, there will be ample opportunity for questions and answers. So I do look forward to engaging with you. So I do want to start at the beginning, which is just to situate where copyright is. And forgive me if you've already heard this information, but just consider this as a refresher. And there is some additional new information at the end of my presentation looking at AI, because that is the buzz topic, isn't it? Artificial intelligence. So when we talk about copyright, it's actually a type of intellectual property, which has to do with the area of law that protects the creative expressions of the mind. So when we think about intellectual of the mind, and as Ms. Douglas pointed out, you have rights, it has value, it is property, it can be owned, it can be sold, it is an asset. So it's very important to understand intellectual property and the different types of intellectual property. And this diagram just gives the big subject areas. We have under industrial property, you would have heard of trademarks and patents and geographical indications. So the UE logo could qualify as a trademark if it isn't already registered with the government office that administers intellectual property laws, JIPO. And we have our logo from JAMCOPY, and you'll hear about Carosa in a moment. So that's the big area of industrial property. Then the next big area is copyright and related rights, which I will speak further in a moment. Then there's another area called traditional knowledge, which has to do with what we've inherited through the indigenous peoples of the lands, their knowledge about medicinal plants, maybe costumes, music, folklore. And I believe that the Maroons and the Rastafarian community, their practices and traditions would qualify under traditional knowledge. And there are some allied rights where you do have property rights over your image, your profile, your silhouette, any particular gait that you may have. Think about Usain Bolt and his To the World. That would be his image rights. He can protect it. You can't be using it without his permission. It's not strictly intellectual property, but it's protected in a similar way. And trade secrets, I think we've always heard about KFC, the secret formula into why Jamaicans love KFC chicken. Well, I understand that is protected as a trade secret. It is a value, it is an asset, and it is not disclosed to the public, but it is protected as a right. So let's go into copyright. And we do have a Copyright Act in Jamaica, which provides a legal basis for administering copyright in Jamaica. And it reflects the basic principles of copyright that are enjoyed by over 170 countries around the world. We're all party to an international treaty called the Berne Convention, which was established way back in 1896, and our local laws reflect the basic principles about copyright. And so what areas of creative expression are protected under copyright? Literary, and we mean books, we mean journal articles, newspapers, also lyrics of songs. Artistic, photographs, paintings, illustrations. Dramatic, by dramatic we also include choreographed pieces that tell a story as well as plays. Musical, the composition of the song. Then there are related rights, the sound recordings, when you bring together the music or the lyrics in a song, but also sound recordings of sound effects, for example. Broadcast, it's the content that is emitted by radio and television stations. They have rights over what has been emitted across the airwaves. And cable programs put together the content to be transmitted to your television. So there are rights under the Copyright Act that are protected in these forms of expression. Now, it's important to understand that copyright does not protect the idea behind the expression. You and I may have an idea to take a picture of the mountainside during the rain. That's free, we all have the idea. But my angle with my camera and your timing with the lighting would be different. And so the expression of taking that photograph, which is unique to you and unique to me, or original to you or original to me, that is what is protected under copyright. It's not the idea about taking the photograph of the mountainside, it is the actual photograph that you take and your original expression. Similarly, for literary work, we may have an idea to write a poem about the rain in October. My expression is original to me and I have copyright over that expression, as is your original expression of the rain in October. So copyright does not protect ideas, concepts, processes, principles, procedures, systems, and discoveries. These might actually be protected under another type of intellectual property. For example, a patent would protect a process that is novel or a system that is novel, but it's not protected by copyright. So under the Copyright Act, we define the author as a person who creates the work. So the author of the book, the author of the poem, the author of the lyrics. And the literary work, as I said before, other than a dramatic or musical work, it is written, it is spoken, it is sung, and it includes a written table of compilation. So maybe the content of the compilation might not have copyright, but the fact that somebody has pulled together content and material from different places and created something that's original to them in a compilation, that can enjoy copyright. And a computer program. I've heard data scientists say that the computer program, the language of the binary, it's a language that they understand. And also I've heard mathematicians also say that mathematical formula is also a language that they understand. But you can also protect a copyright program under copyright, a computer program under copyright. Now, what is important to understand are these four areas that cover the rights. There is a protection of your right once the work exists in a written or recorded form. So if you have voiced the poem out of your head, but you have not reduced it to writing, you don't have copyright protection. It's when you've typed it out, it's when you've recorded it on your phone, when you have written it by handwriting. It has to be in a recorded, a tangible form. That is when the law kicks in for you to have copyright protection. There's no requirement for registration. Nowhere in the world is it required for you to register your work in order to have protection. It's automatic once it's in written or recorded form. But make sure you put your name, make sure you put the date, and the international symbol for copyright, which is the letter C inside of the closed circle. Now, not putting your name and the date and the C doesn't mean you don't have copyright. But think of it, when somebody takes up a piece of paper and there are words written on it with a poem, seeing the name and the date and copyright is an immediate signal that this person is claiming authorship of the words on this paper, and they are claiming to have copyright over the work. Not having it doesn't mean you don't have copyright, but it's an immediate message to anyone coming into contact with the work that there is ownership to this person being claiming authorship over this work. Then you might say, well, how do I prove that this is my work if I don't have to register? Well, there are several means. You could mail a copy of the work to yourself through the post office by registered mail, and this is called self-registration. So you put a copy of the work in an envelope, you seal it, you put your name and address, you pay the fee, you keep the slip, and when it arrives to your address, you don't open it, keep it sealed, you staple on the slip, and you keep it somewhere secure so that should ever you have to go to court And to say that somebody wrote the poem, the exact same poem, but they wrote it 2 months after me, they must have seen it or heard me perform it, and now they're saying it is their work and it's really mine, you would provide this date stamp through the registered mail, through the post office, to say, I came up with these exact words in this form on such a date. Then JIPO, which is the government office that administers intellectual property in Jamaica, they offer a voluntary registration system where you would carry a digital version of the work, you pay them a small fee, and they would keep an e-copy, a soft copy of the work, and issue you with a declaration to say, on such and such a date, this person by this name deposited with us a soft copy of this type of work by this name. Now, JIPO is not saying that you have copyright, they're simply attesting that on such a day you brought a work in such a form, and they're keeping a soft copy of it. So it's similarly to the self-registration. It's just something to corroborate your claim of authorship over the work. Then I'm sure you know, librarians, that you are required under law, the Legal Deposits Act, that if you have published a work in Jamaica, in order to build up our archives and our national heritage databases, you are required to deposit a copy with National Library. And National Library celebrated 20 years of legal deposit last week, I believe. So this is actually a requirement under law for you to deposit a copy with NLJ. And then affiliation with JAMCOPY. If you have published the work and it's available on the market, you can also affiliate, and that's also another corroboration of your claim to authorship over a work. So you've protected, you have your proof of authorship, then you can exploit. You could sell, you could give away freely, that's up to you. You could have an e-book, you could have a hard copy book. Maybe somebody's interested in taking your poem and turning it into a play or into a movie script, but you're now making the work available to the public for their enjoyment. But then, as sometimes happens, persons use your work without your permission in a way that you have not permitted, but the law then gives you grounds to take either criminal or civil action against persons who use your work without your permission, and using your work without your permission is called infringement. But this is also provided for under the Copyright Act. Now, what are the two types of rights that you have? I've talked about protecting, talk about your proof of authorship, talked about your commercialization, and talk about taking legal action if infringed. What are the two types of rights that you're going to be actioning? There are economic rights and moral rights. Economic rights, as the word suggests, has to do with money, some financial benefit. So these activities here, copying, issuing copies to the public, performing, broadcasting, making an adaptation, communicating to the public by wire or wireless means, all of these acts are exclusive to the owner of the work, and anybody wanting to do any of these actions must get permission from the owner of the work, or else it will be infringement. And when we say copy, I mean a photocopy, I mean a literal photocopy, I mean uploading and downloading, I mean making a second version of the work. Copying, anybody copying the work, you need to get permission. Issuing copies to the public, so a book fair, putting it in the bookstore, distributing on email, those you need to get permission. Performing in the public, whether it's a song at a concert or a poet performing at a literary event, if you are going to perform it in JCDC, for example, you would need permission. Broadcasting it over the airwaves, need permission. Making an adaptation, turning the lyrics into a movie script, you would need permission. Communicating to the public by wire or wireless means, so making it available on the internet, so a blog or YouTube, need permission. Any of these activities, you would need the permission of the owner of the work in order to carry it out, in order to not be charged with infringement. And they can ask for a fee, a royalty, some financial payment for you receiving permission in order to carry out these acts. Then the other type of rights is the moral rights, and that is the right to be identified as the author. So if you write a poem, you don't want to see Miss Massey have her name attached to your poem. You want your name to be on the poem. If Miss Massey have her name, then you say she has infringed your moral rights. She has infringed your right of paternity. Or if she has used your artwork or your movie in a setting that would be derogatory or demeaning to your reputation, you could also say, but you are infringing my right to integrity. I did not intend that work to be used in such and such a setting. What if persons heard about it? What would they think about me? So this is also provided for under the Copyright Act. And you also have the right to not be falsely attributed as an author. So imagine you're a famous author like Mervyn Morris, and somebody writes some dege poem that really don't have the quality, and they put Mervyn Morris on it. And person say, but Mervyn, your quality has declined. And he said, but I didn't write that poem. Somebody want to ride on the back of his popularity and his fame by attributing his name to their poor quality work. He can also take action under the Copyright Act. So, economic rights and moral rights. Now, I want you to hear a phrase or a term that I use, and to be clear, I talked about the owner of the copyright work, which is distinct from the author. Do you remember who I said the author of the work is? The author of the work is what, or who? The creator, the person who actually wrote the poem or wrote the book. But because we are talking about property rights, we're talking about assets that can be bought or sold or licensed, the author can make the decision that I am going to give over my economic rights to someone else. So the author might say, I've written this book, but I'm going to ask a publisher to make copies and to issue copies to the public and to make it available online. The author is going to give the publisher those economic rights for a period of time in return for receipt of royalties. So the publisher is going to be exercising the economic rights as the copyright holder, even though the author retains the moral right to be identified as the author. Are you following me? So I've used some terms that I mentioned previously. So the author will be named on the front of the book, and they have the moral right to be named on the front of the book. But the author has asked a publisher to copy, issue copies to the public, make it available, communicate it, and so the publisher is going to be exercising those economic rights according to their publishing contract that they'll negotiate and agree on. And the publisher will receive money for books being sold and will pass on a percentage of those proceeds to the author as their royalty. So both the author and the publisher are enjoying economic rights. It is possible that the author may say, I want to have nothing to do with this, I want to completely sell all my rights, and they may do so. And whoever buys the complete rights to the work now becomes the copyright owner of the work, but the author must still be named as the one who created, who wrote the work. Now, we talking again about property and value and assets. You can divide the use of the works, we call it divisibility of rights, into multiple economic streams, multiple income streams by geography, types of use, and duration of the use. So for example, J.R. Tolkien wrote Lord of the Rings. It was published as a book. Years later, it was turned into a film. I think there were also maybe a television series and several other offshoot activities. He would have given rights for the book, perhaps in England to be sold. Maybe he might have had a different distributor in the US. So you're getting income from England, you're getting income from the US. Then the movie was made, the movie film studio, they would have rights to distribute the film in different parts of the world. Maybe somebody handled it in Asia, maybe somebody handled it differently in Africa, somebody has handled it in Europe. Those are also different income streams coming to the author. And maybe he might have given rights for the book to be published and sold by this publisher for 5 years. And after 5 years, the rights return to the author. So it's possible for you to divide it up by use, by duration, by geography, and that way you're having your work being commercialized at the same time in different ways, and you're earning through multiple income streams. Now, we're talking about your rights if you are authors. I want you to keep in mind these different terms and roles, the author as opposed to the owner. The law, the Copyright Act says that you are the first owner of the work. The author is the first owner of the work, unless there's a contract that says the economic rights or the ownership belongs to someone else. And one example is in the circumstance of employment. If your employment contract says that whatever you author, whatever you create in the course of employment, you will be named as the author, but you will not own the work. The economic rights won't belong to you. They'll belong to your employer. Then the ownership and the economic rights goes to your employer, but you retain only the moral rights. And if the employer commercializes your work, for example, you have written journal articles, and these are sold, or there's a subscription and income comes in through these journal articles, the employer receives that money. Maybe in the contract there's some discussion about you getting a percentage of the royalties coming in from the commercialization of the journal articles. I don't know, but this is something to be aware of if you're an author in an employment circumstance, to see what your employment contract says about the works that you create in the course of employment. Okay? Understanding? Things to be aware of, terms and meaning of terminologies to be aware of. Now, the Act does allow for some free uses. The Act allows for some circumstances where you can copy the work, you can perform the work, you can use the work without having to get permission and without having to pay a royalty. So it creates an exception to the rule. Remember, the rule is if you do any of those activities, you need to get permission, you might have to pay a royalty. The Act allows circumstances where there is an exception. In the case of research and private study, so I have to do a little paper for high school history class, and I go to the library and I research and I write up things, make sure I put my references, make sure I put my acknowledgement to say where I've taken information from, but I don't have to get permission from the author or from the publisher in order to cite them in the work. Or if I'm critiquing, went to a performance, went to a play, a new book was written, I do a book review, I'm critiquing it, I'm publishing the critique, don't need to get permission or pay money to do so. If I'm reporting current events, it's the news, it's something that's happening, you're reporting on it, it's current, don't need to get permission. Except for photographs, you do need to get permission to replicate the photograph. And the law also allows libraries to do a certain amount of copying without having to get permission or to pay a royalty. But if you look in the Copyright Act regulation, there is a form for persons who are making copies at the libraries to fill out, to say that I'm using this for my private research, my own private studies. I am not making multiple copies for the whole class, because if you're making multiple copies for the whole class, it's now beyond private, it's now in commercial quantities, and you're going to need a license. But there are certain exceptions for the libraries. Also, if you're handling material that might be fragile or rare, or there's a single copy, the Act allows a library to make a copy in order to preserve that rare copy, or if it has been destroyed and you need to get a copy from another library, or you need to provide a copy of what you have for another library because their fragile, rare copy has been lost or destroyed, you're allowed to do so under the Act. So there are certain exceptions for the libraries. And when these exceptions, they're called fair dealing. You're not taking away the commercial value of the work or the commercial opportunity for the copyright owner to exploit their work. You're handling it in a fair manner. Fair means the nature of the work, fair in terms of how much of the work is being used, fair in terms of the purpose of the use, and fair in terms of the potential market. So which is why I said when the student come to say, I'm making a copy for my private research, that 111 copy is fine. But if they're coming to make copy for the 50 of them in the class, that is affecting the commercial value. That is affecting the market of the author, because they should be buying the book or getting a license to make that many copies of the work. There are also exceptions under the Act for setting exams. You don't have to get permission or pay a royalty if you're setting questions or using extracts of work for exams. And as I said before, you must cite, give acknowledgement to the source of the work. Now, just to say how long copyright lasts. The general duration around the world is the lifetime of the author, plus 50 years after you've died. So that's recognizing that if you are a famous author and you're earning well from your works, for 50 years after you have passed, you can bequeath your assets, your copyright assets, to your estate. Please make sure to write a will. Everyone, whether you have little bit or plenty, it's a good thing to have your will and instruct who is to get what, who is to own what. All right, so just as a general legal encouragement, please do make a will. Do make a will, all right? But for 50 years after, your children or your grandchildren or whomever you bequeath your assets to, they will be able to enjoy your fame and the recognition of your literary work. For 50 years after, they'll be able to enjoy the economic rights of your work and to continue receiving royalties from the use of their work. But in Jamaica, we're extra. In 2015, the act was amended to increase from 50 up to 95. So right now, it is life plus 95, which we can have a discussion after, because an extended period meaning that you're going to have to continue getting permission and continue paying royalties for the use of the work for life plus 95. But this is what it is under Jamaican law. It is not this in other countries. In the US and in Europe, it's life plus 70, and other Caribbean countries it's life plus 50, but this is what it is in Jamaica. So now, we want to get to the matter of getting a license. So that example I gave you, if the students come in and they really want to make copy for the 50 students in the class, you can't handle that as a library. You're going to need to get permission. You can't give permission for those 50 copies to be made. Where do you go? Well, there are 3 organizations in Jamaica. We're called collective management organizations because we are acting on behalf of the collective group of creators who have asked us to be the go-between for them, between them as the creators and the public users, to give permission for use of the work. So there are 3 of us in Jamaica, JAMCOPY and JAMS, maybe you've heard of them. They are the CMOs for musical works. JAMCOPY represents authors, lyricists, composers of musical works and publishers of musical works. And JAMS represents record producers. So if you're holding a fete or a party or a concert and you're going to be playing music or you're going to have live music, you're going to need to get a license or permission from JAMCOPY for the public performance of those musical works. JAMCOPY, our specialization is text, meaning literary, and image-based or artistic works. So any literary work or an artistic work embedded in a literary work, so illustrations, photographs, graphs, that sort of thing, in a literary work, we will be representing the authors and the publishers of those printed works. Now, just to remember that copyright is a private right. You don't have to go through the CMOs. You could have direct connection with the author or the publisher or the music creator in order to get permission to use their work, whether it's to copy it or to have it performed. But an institution like a UE, you're using millions, maybe hundreds and thousands of works. It will be time consuming and costly for you to go through, let me see, I'm missing a slide, oh there. To go through or to try and track down every single author and every single publisher and in a timely manner in order to have permission to make use of the works. Think about a radio station, they're playing thousands of songs every week, every month. It will be timely and costly for them to track down every record label or an independent to get permission to play the music on the radio. And so we, as the go-between, help to cut down that cost and time by being the middleman between the creator and the user. So just to say, and Ms. Douglas had raised the question about the legitimacy of the licensing bodies. We are licensing bodies in Jamaica. Just to say that JAMCOPY, we've been around for 26 years. We are an incorporated company. We were established in accordance with Section 87 of the Copyright Act, which allows for licensing bodies to be established in Jamaica. The government of Jamaica recognized us from in 1999, and in fact, the government of Jamaica was our first licensee in 2001. We're not alone. There are 5 of us in the Caribbean, in Barbados, in Trinidad and Tobago, in Belize, and the Eastern Caribbean. And we're also part of an international federation of other CMOs, and our specialized title is Reproduction Rights Organizations. There are over 150 of us in 80 countries around the world. So we're legitimate and we have standing. The question that Ms. Douglas asked was a case that had been brought by JACAP against users of music who refused to take out licenses and to pay their licenses, KFC being one, and Horizon Cable. And they claim that they don't need a license or that JACAP doesn't have the right to act on behalf of their users, which is not true. And I want to say that in particular, the most recent ruling, JACAP and Horizon, I'm just going to get some water. Right, the attorney for Horizon and the judge came to the conclusion that JACAP needed to get their licensing system first approved by the Copyright Tribunal before they could approach users. This is not true. This is not what the Act says. The Act says that a user can go to a Copyright Tribunal to ask whether the fee is a fair fee, but it is the user who has the first right to go. JACAP can't go to the Copyright Tribunal. JAMCOPY can't go. JAMS cannot go. We can only respond if a user goes to the Copyright Tribunal and says, is this a fair fee? After they've gone, then we can appeal to the tribunal. But the first right, the first step is for the user, not for the CMOs. The court misread the Act, and their ruling is legally, in terms of their argument, wrong. And if you're interested, I wrote an article about this, which was published in the Gleaner and in the Observer, responding to this ruling and the arguments made by the lawyer for Horizon to point out their erroneous and flawed reasoning. So to say that we are legitimate by the Act, we are a legitimate organization, and therefore we have the rights to act on behalf of these creators in licensing the users of their work. So in terms of what JAMCOPY does, in terms of licensing the copying of works, and this is just the definition under the Copyright Act. A work that is literary, dramatic, musical, artistic means a reproduction of the work in any material form. Any material form. So what that means? Well, back in the day, it would have been handwriting, that's making a copy of the work, or it would have been the lithographic machine or the stenographer, or now we have photocopying machine or a fax machine or the digital copying or literally taking a photocopy. For us, a copy is a copy is a copy. If you've made a copy of the work, you are required, if it is not under fair dealing, you are required to get permission from the owner of the work in order to make that copy. Downloading is copying, uploading is copying, emailing is copying, faxing is copying. A copy is a copy is a copy. So as I said before, JAMCOPY and the other two CMOs, we are the bridge between the users and the creators. And so this schema represents the cycle of our role in supporting the creative industries. The creators, the authors and publishers, when their work is available to the public, commercially available to the public, so you've written your book, or your journal article has been published, or you've written a column in the newspaper, you come to JAMCOPY, you would fill out our affiliation agreement, you would give us a sample of your work, and by sample I mean the front page, the back page, and the copyright page with the ISBN. We would negotiate with users, and we operate on the premise that once your work is publicly available, it might be copied. It's possible, we don't know 100%, but we act on the presumption that if the work is available, it might be copied. We have bilateral agreements with many of those territories I mentioned to you across the world. So in fact, we are representing not only Jamaican authors in Jamaica, we're representing American and Canadian and South African and Japanese, and we have 43 bilateral agreements. And they are representing your works in their territory. So through the relationship with JAMCOPY, your works will be represented in the US, and in the UK, and in Canada, and in Argentina, and in Brazil, and so on. We negotiate with the users, like a UE. We grant them a license, and so the copying that takes place by staff, by students, is therefore legal because of the license. The license sets out the parameters of what can or cannot be copied. We receive the fees from UE. We then pay these fees after we take out for our administrative costs to our affiliates, the authors and publishers. That's their royalty and distribution. And we just do as we're doing today, encourage the respect of copyright, encourage authors to join JAMCOPY when they have published their works. And if necessary, we join in enforcement activities. It's not a regular thing because it is a private right, but where we can support authors whose works may have been infringed, we do so. And so this is from our website. I invite you to go to our website, jamcopy.com. Lots more information about us there. And this is just a snapshot of some of our licensees. You would see the UE logo. There's also IUC, Mona School of Business, CMU, UCC, University Technology, Hart Trust, NTA, and the community colleges. And just to mention, perhaps you know about Creative Commons, where persons may choose to refrain from exercising copyright. They want to share their creativity freely to others. It's not a termination of copyright. Copyright still lasts for their lifetime, plus 50 years or 95 years after death. But they have made the choice is that I'm going to suppress or I'm not going to enforce my copyright in certain ways. I'm going to allow you to use my works, but just make sure you put the Creative Commons symbol, which is the 2 C's inside of the circle. So what are you allowed to do on the Creative Commons? You could either use a work and only attribute, just say I got this from Philippa Davies. I can commercialize it, but just say that it was Philippa Davies who wrote it. I can share it with others, or maybe I can share, give attribution, but I can't commercialize it. Or I'm allowed to share, give attribution, commercialize it, and create derivatives. So for example, taking the poem and turn it into a story, or turn it into a graphic novel, or turn it into a movie. So there are different permutations under the Creative Commons. You would have to see what the person says, but they are making the choice not to enforce their copyright in order to allow others to use their creativity and to grow through their creativity and to share it with others. So just a word about AI, and particularly generative AI, where you can put in prompts into the machine and it produces a literary work or an artistic work. The question would be raised, is AI-generated content eligible for copyright protection? Can the machine go to JIPO and say, I have authorship over the work? Is it original? Is AI-generated content original? What is AI trained on? Because we know that the machine is pulling content from different sources. Where are they pulling it from? Is it copyright-protected material, or is it material that's in the public domain, meaning that copyright has expired? So for example, Shakespeare's works, he's been long gone, more than a lifetime plus 95 years. And are the prompts, the general or refined prompts, is that equivalent to creativity by the human user? Well, the matter is still under discussion, But what we have found, and to say that our act, when it was passed in 1993, it is patterned off the UK's 1988 Act. It was contemplating this development of technology down the road by recognizing that the author is not only the person who writes a poem or writes the music, but also who makes the arrangements necessary for computer-generated literary, dramatical, and artistic and musical work. So it was thinking ahead. So our act can recognize AI-generated works. When we say computer-generated, meaning that the computer generated it, in that there is no human author, but there is an author who made the arrangements for the work to be created. So can the machine have rights? Well, here's the thing. The principle of copyright is that it is protecting the original expression of a human being. So a machine cannot have rights. You, the human, you would have rights. But we recognize that your pen is a technological device. The laptop is a technological device. The laptop doesn't have rights. I have rights, but I use a device to bring forth my expressive creativity. So machine works are not copyrightable. But I, as the author, using the machine, I can gain copyright from an AI-generated work. But how much? How much of that AI-generated work reflects me as opposed to the algorithm of the machine? Who is the author? Is it the AI developer who designed the machine and programmed the algorithm and puts its contours and limitations? Or is it the user who puts into the prompt, give me a picture of the Blue Mountains on a rainy day in Jamaica, right? Who owns it? Well, what we've been seeing in decisions, court decisions, out of the EU and the US among other places, is that output that is purely responsive by the machine to the human prompts is not protectable. I just put in the prompt and the machine gave me something. It is me changing that output. It's me making some changes myself to the layout or the color scheme or the background. There has to be something originating from me to this output in order for me then to claim copyright over this AI-generated work. So in last March, the US Copyright Office actually issued, after they started receiving submissions where people are claiming authorship of works that are AI generated, they put out this guidance to say that you can claim copyright ownership or authorship, but you've got to show where you have added something, overlaying that machine output that you can say it's original to me. So for example, this was submitted by Kashta Nova, a comic book. The images were generated by AI, but she wrote the original literary text. So she can have authorship, claiming authorship and ownership of the words of the graphic novel, of the comic book, but she cannot claim authorship of the images, the pictures, because that was purely produced by the AI-directed machine, and she made no alterations to it. So only the words of the book which she have rights to. But where is this content coming from? And this is a challenge that we're facing, is that the AI machines are not distinguishing where they are getting information. They're scraping up content off the internet. And that could be copyright protected works, and that could be works that are in the public domain. It is not making a distinction. And they're not getting permission. They're not asking permission from the rights holders. And it's not covered under a legal exception. And so the rights holders could take legal action against the AI developer that you're infringing my rights. You're using my content, and now you're commercializing the content when people are using your AI program if they have to pay a subscription fee. And this is a form of infringement. So in May this year, 300 book publishers and over 10,000 creators in Canada, they issued a press release saying there needs to be regulation, there needs to be law reform to put a stop to AI developers just having this freedom to take content from anywhere without acknowledging my source. So even if you took my content, you haven't said that I took this from this blog page or from this website. You're not attributing the work to me, so you're both infringing my rights and my moral rights. And they're saying, no, there needs to be proper regulation. If AI is going to be with us here on out, we need to have regulation and recognizing the rights of creators. Transparency is essential to the development of a fair and safe AI ecosystem. Otherwise, generative AI models will continue to develop in an opaque, unfair, and undemocratic manner without respecting the rights of creators. So let me just conclude to say that we haven't yet tested in the Jamaican space about protecting AI-generated work directed by a human, but we still have that section available in the Act. And also to say, in the UK, they've had it from 1988. In 2 years ago, the UK government said that even though people have been raising the issue about having law reform and AI, we're still discussing it, but there's no reason to change the law. So in the UK themselves, they have not changed their law. They have not changed that provision, which is similar to what we have in our law. Our law also does not recognize text and data mining, which would allow AI developers to get permission in order to scrape your content in order to feed this into what they make available. Maybe we need to change the Copyright Act to recognize text and data mining. Could fair dealing cover AI training? Possibly not. I've heard from Minister Dana Morris-Dixon that there is an AI task force, and they have put together a report which should be coming out later this month. So we would need to see what recommendations they say in there with regard to protecting intellectual property. Are they going to propose law reform? Will the AI developers in Jamaica be required to cite sources? Will right holders be allowed to restrict the use of their works for training content? The future will determine. So let me just end by saying, if you plan to use AI, or if you are using AI tools to make new works that you want to protect copyright, just remember that you need to show some originality from you. You need to make some modifications for you to be able to say, this was what was put out by the machine, but these changes, they're original to me, and therefore I can claim copyright over those works. So thank you very much. I hope this was useful, and I await your comments and questions. And you can follow us on social media, or if you want to give us a call or come and visit us if you have published works. We're at 17 Ruthven Road, right next to JPS, across from Four Seasons Hotel. Thank you for your attention.
Thank you very much, Ms. Davies. That was certainly an excellent and enlightening presentation. I just want to make two comments. One about the divisibility of rights. I found this quite interesting, and I'm now thinking about entrepreneurship in the University of the West Indies, because to be able to divide up this right in such a way that we can gain economic benefits by geography, type of use and duration of use and so on and so forth. A lot of things are going through my mind in terms of our own publications out of various departments. How can we monetize all of this and give the rights, say for example a license to carry one of our publications in a database. And we have started, and I think it is an opportunity for us to move forward. So thank you so very much for having included that divisibility of rights. It's really instructive. Another comment I want to make about the presentation is when it speaks to not copyrighting ideas. How many of you knew that ideas could not be copyrighted? It is the expression of those ideas that is copyrighted. And so now that you are aware, now you know that your expressions should be published and be copyrighted so that you can gain economic benefit. And certainly you would want to be among those in the halls of fame who are able to, others in in the upcoming generation is able to see your works through the citation in their own scholarly publications. I have one question for you before I raise questions from the floor and online. Is there anyone monitoring the MonaMedia online to see if there are questions that have been raised? So I'm going to ask my question first, and then I'm going to ask you to raise questions. What is it like? I'm not sure if this is an appropriate question in terms of those who are paying licensing fee to JAMCOPY. Where, for example, JAMCOPY receive licensing fee from the University of the West Indies, and I'm proud to say that we are one of your very important clients. And so where other institutions do not pay licensing fee to JAMCOPY, but those institutions have authors and they are affiliates of yours, is that kind of economic benefit taken into consideration when paying royalties?
So let me see if I'm understanding. If an institution has authors within or employed to the institution and they create works and they're used by the institution, right? Well, our license does not include institution-created works. We're licensing you to use the works of other people. So for example, if you have, in the course of employment, people are creating works and you're using it here at the university, you own the rights, or you have a direct relationship with your own authors to determine how your works will be used. We wouldn't get involved in that because that's an internal issue. We're licensing you using other person's works. So we wouldn't get involved in that. Yeah. Okay. Yes? Yes? Yes.
With regard to, thank you. My question is about AI acknowledgement. I noted your example with regard to the graphic novel and the author having ownership of the text. But what about purely literary works where you have generated something through a prompt and then you continue to modify and change as you have indicated? How do you go about copyrighting a work like that or offering the necessary acknowledgement? Have there been any examples of that?
Right, so it would be the similar principle whether the final work reflects your originality or whether it is the result of the prompts that you have put in. I don't know if there's a percentage. I mean, I don't know how you'll be able to quantify 50% is me and 50% is a machine, but the question is going to be, is this work going to be original to you? But think about it, if you put in a prompt, somebody could put in a prompt, and I mean, I understand that the way the AI system works, you never ever get the same result, even if you put in the same prompt each time, because it's always taking new information. The question is, somebody could still put in a prompt and still get a similar outcome to yours, and if you have not added your originality, you can't turn around and say that the person who has something similar to you is infringing your works, because you have not added a degree of originality to your works. So right now, I would say that yes, you could put in the prompt and you add to it, but there's a risk that other persons will be doing similarly. And if they don't add their originality, then you can't say that they've infringed your work, you know, because you're both starting with the same base point and the same source material. You know.
Thank you so much for this presentation. I feel like every year we can benefit from your coming to the Mona Library, just refreshing, and there are always new questions. So I have two for you.
Sure.
I wanted you to remind us about the percentage of, say, a literary work, what percentage is covered under fair use. So when the students come, what is an appropriate number based on the work for fair use? The other question, though, speaks to material in special collections, for example, that may be out of copyright, maps, rare books, but we still want to retain some control over use. What would be your advice, or where do we go for guidance on use of rare materials that as a library we may want to say we are not offering this sort of reuse rights, but you may consult, but you may not reproduce, you may not place it in a publication or so on. Those are my questions.
All right. So in terms of the students, the basic principle of fair dealing is that it's research or private study. And so you would have to satisfy yourself that this is for a private use, but you may be able to discern whether they have been directed by a teacher or a lecturer, and therefore there would be other students who would be coming to make copies. But because you have a license from JAMCOPY, you're good, so that they can be making their multiple copies, because the license would cover instructor-directed copying. In terms of the rare works that you have, well, if the work is out of copyright, meaning that it's past the Life Plus 95 or the Life Plus 50, then it's for you to set up your own protocols for providing access to the work or making copy of the works. If works have been, for example, donated by families out of the archives of family, maybe your protocols would say, this is what the family has allowed us to do or we cannot do. So for outside of copyright works, it's you who would be setting the terms and conditions of use. If it is still under copyright, then these principles would still apply. Basic principles would still apply.
Thank you again. This has been really, really enlightening for me and very interesting. My question is, broadly, not necessarily locally, but internationally, what are you seeing in terms of persons just making copies of books and placing them on the internet? We're seeing this a lot. We know, and as an acquisitions librarian, MC, we know the sites where people just put full copied works and put it up. What are the powers that be? I know there was one incident where the FBI shut down one particular site, but as one site is closed, another one opens up.
Right.
And people just feel free to put up other people's, and this is in the realm of textbooks especially, we're seeing that.
Yeah.
So what internationally is being done? And I don't know that there is anything that can be done, because the internet is ubiquitous and anyone can put something up there.
Right.
But we are understanding that it is affecting authors, it is affecting the use of material from libraries,
Right.
and other such, entities. And of course, authors are not getting their fair, yes. So what internationally, if you know of anything, is happening in that realm?
Right. Well, you've outlined the challenge. Before there was ubiquitous internet, there was a photocopying machine where multiple copies were made, and now with a click, material gets sent. So infringement is very much a reality, a raw reality for any kind of material content, not just books, but just think about music as well. And the fact that persons don't respect the boundaries or the property rights of others, it is a real sore reality. And so we say to our affiliates that even though you would join JAMCOPY and we would license institutions and you would get a royalty, it in no way represents the universe of copying that is taking place. There is no way for us to be able to track every single use. It is impossible. This represents a percentage and the idea that we want to inculcate in the culture, that you should respect the creative expression of others. And so the licensee, the institutions like UE, are vital partners to communicate and build that culture. Internationally, well, it is really, remember I said that copyright is a private right. So I can't force you as an author to go and take legal action. It's your choice to do so, and the Act provides you the means, whether it's civil or criminal action, but it is a private right. So you will hear of the music companies, and they have deep pockets that they can pay the lawyers to keep track of people who are downloading or what have you on the internet. If a person does not have that means, then they're probably just going to, sadly see the use of their work. But then there's also technological ways of either encrypting or watermarking or doing some sort of way of blocking copying and pasting of the work if it is available online, for example. But with the book, taking up the book and making copies, that is a very sad reality. I remember during COVID, when teachers would pass around on WhatsApp the entire textbook because they needed to make it available to the students, right? And I also know that one of our board members, who is a publisher, laments the circumstances in Guyana, where even though they have a Copyright Act, nobody regards it. And so they don't want to do business in that CARICOM territory because they know their works are going to be photocopied, and they will be losing and facing loss in that market. So infringement is a reality. We try what we can, but it is a private right that the author has the choice to exercise or not to exercise.
There's a question on YouTube, and Susan Williams is asking, how does JAMCOPY verify that persons claiming authorship were actually the authors of a document?
Right, great question. Thank you, Susan. So when an affiliate comes with their work, this is why we ask for the back page, front page, and the copyright page, and our bibliographic administrator, who is a trained librarian, then does a search through all of your databases like WorldCat and all the others to find proof that links this person with this work and evidence of it being commercialized, so the work has to be available to the public. We've had persons come in and say that this is their work, but they don't publish it yet. We say, no, after you publish it, you can join JAMCOPY. And we've had persons come in and say that they wrote the work, but guess what? They sold their rights to the publisher. They didn't retain their copyright, and so they couldn't join, but the publisher could. So we ask questions, and our bibliographic administrator takes the lead in checking all the various spaces. I need to point out, though, open access. A lot of persons go through open access because this is a great way of being recognized and cited. But open access means people can copy it without getting permission or paying a royalty. So we would not be able to accept an open access work for licensing because our licensing is based on the premise that you still retain some sort of control over the copying of your work or intend to retain control. Open access is like Creative Commons. It's like you've given it freely. And so we wouldn't be able to accept works. Let me also add, print on demand. That's a very popular route for self-publishers because it reduces the costs and not having to keep things in stock. But print on demand means that at the time of publication, it exists in a digital form and it doesn't become a physical copy until somebody makes the purchase. We wouldn't be able to license that because we don't know if it has actually been made a physical copy and been purchased. We're not able to track that. It's only if the book exists in a hard form, a hard copy, made available, and we then presume that it will be bought and maybe copies will be made. So print on demand would not be licensable by JAMCOPY. It's great for all these developments for you to get your work out there, absolutely. But our remit is a very narrow aspect of the management of your rights.
With reference to rare material that we concede had come out of copyright and so on, an institution such as the library may wish to offer rare material for researchers to use and so on at a charge. Does this represent an infringement in any way, ethically, morally,
That's you
economically.
recouping your costs, so no.
Okay. So it's okay to
Because
allow
they're
research.
paying for access to the
Okay,
work
for
that you have
access.
retained and that you're preserving, right? So, no, that is an internal protocol.
Okay.
Yeah.
I know that you said that print on demand. I know that you said that print on demand. Print on demand.
Yes, it's on.
Yes, thank you. I noticed you said that print on demand is associated with electronic version, but I know of a movement in the United States where theses, for example, dissertations are done in print, but there is a print on demand that is done which gives institutional branding on the cover and sold off as a one-off publication. So in that sense, would JAMCOPY license that format?
Once we have proof that the work is not in a digital form only, it is in hard copy as well, then it would be licensable. But if it is only in digital copy, we are not licensing solely digital works.
Thank you. So I have a follow-up question as well. You mentioned self-published works. What is JAMCOPY's position on self-published works? Because the spectrum include persons who would, for example, develop a company, a personal company, and then they publish it from their personal company. That kind of self-published work, what is JAMCOPY's position on that in terms of payment of royalties?
All are welcome. Our basic principle is that the work exists in hard copy and it is commercially available to the public, and that your name on there, you're the author of the work and you still have copyright over it.
Thank you very much. Are there any other questions?
Thank you. All right, I've always been hearing that for our work, whether you photocopy or scan, it should be, say, 10% without infringing on copyright. Is it the same 10% still?
Well, if you're photocopying an extract of a work for your private research or study, that's fair dealing. But if you're going to be doing it in multiple quantities so that it is of a commercial value, then the JAMCOPY license would kick in, and you can do a whole newspaper article, you can do a whole journal, and you can do up to 20% of a book. I'll just ask our licensing manager, Jamila Kasim, to answer that, please. Thank you.
So it's 15. Thank you. So is this on? Yes, it's 15% is our limit, and 20% or a chapter of a book, whichever is less. So those are the limits.
Right, but a whole newspaper article, or a journal, or a poem, or a poem.
Right.
Right.
But our limit is 15%, no more than 15% of our work.
And one quick question, for material that is placed in course containers, is there a different permutation for that? Different requirements?
Right, course.
Course containers, you would have a license with the UWI,
Right.
and we do have, well, almost every course would have a container which is perhaps controlled by the lecturer. Is there are there
Right, the course
requirements
pack. I'll let her
and-
answer on the
Yes.
course pack. Yeah. Pack, yeah. Yeah.
Thanks. But what is the question in relation to the course pack? Because
percentage?
our percentage is still 15%. So the blanket percentage for the license is 15%
Of the work.
of our work.
Of the work.
Oh,
For the duration of the course? Yes. Yeah.
sure.
Yeah.
All right.
Thank you.
All right, thank you very much. Thank you so very much. I think we're running out of time because I also wanted you to touch on that same 15%. At some point, they had said 25%, and then they said 15%, and after the 2015 amendment, the argument surrounded 15%. Is that 15% considered to be a substantial, if it is a substantial part of the work, can you still copy that 15%?
All right, so it has always been 15, but during the COVID years, for 4 years, we increased it to 35 actually for all of our licensees, but that was because of the exigencies of COVID, but it's back to its normal 15 and 20. And substantial is not about amount in terms of fair dealing. Substantial is really the essence of the work. So if you are, but that's only for fair dealing. It's not for what you're doing. You copy what you need to copy, but up to 15% of the work. So substantial only comes into play for fair dealing, and whether what you've copied under fair dealing, whether you have taken the essence of the work or whether you're just copying, a few pages. So substantial is only on. Right. No. I think the librarians just need to ask, is this part of a class assignment? Is this part of did the teacher say, just to satisfy yourself that this is a one-off, or if it is bulk, because a whole heap of students going to be coming and making a copy of it, then you know that you have a license to cover it.
Thank you very much. And by asking that question, something came in through my mind, and I know that the legislation have that form that you can fill out to determine essence as well as percentage and so on and so forth. And perhaps because our processes tend to be a little bit lean towards manual more than the electronic, perhaps what we really ought to do is to have something in place where they would do an electronic form so that the data can be archived and harnessed. Thank you so very much. Yeah, sure, definitely.
Right, just to say that also, we ask all of our licensees, in fact, you're required under the license to submit logs to JAMCOPY, logs of the works that are used by the students, that are copied by the students. Why? Because when we pay our royalties, we want to be as close as possible to actually matching payment with work. So when we get the logs to say that this book by this author was copied 5 pages out of this, 2 pages out of this, then we in our payment can say with this degree of accuracy, we know your work was copied. Otherwise, as I said, we're paying on the premise that if you've published the work, we assume that your works are being copied. So it's a general royalty payment. But if we can get the logs, we can make an additional payment, which we call title specific, because we have the specific title that's being used. And that's to the benefit of the author. They get their general payment and they get title specific. And if we can get logs, then we can have a real good picture of the works that are being used by institutions. So that also is helpful to us in our administration of your rights as authors and publishers. So thanks for the logs. Thanks for the logs.
And thank you very much for that confirmation. And therefore, in terms of digital transformation, we must get there because other jurisdictions are operating on that premise and in that fashion where they are able to harness the logs, the request, and also the feedback from the actual service that is provided to say you may have asked for 5 pages, but we were only able to provide you with 2 pages. And so the reproduction rights organizations can adequately and efficiently determine what the royalties should be. US Copyright Clearance Center does that, and the British version of that as well, and Canadian. So we are being repositioned by this presentation, and that is perhaps one of the resolutions that should come out of this, that we should be able to provide more accurate usage logs to drive and determine royalties payments. Thank you so very much for the presentation. Excellent, excellent, and I like the dynamics from any other thing that is mentioned online, Ms. Sadler? Thank you so very much. Such a robust discussion. So at this time, we are coming to a close, and so we ask that Ms. Heather Thompson come forward and present a token of our appreciation to our JAMCOPY representatives, and thereafter she will give the vote of thanks. So these are my final words, and later you can have a token of our appreciation across there. We cannot afford much, but with increased royalties out of JAMCOPY, in the future we should be able to fund more refreshments at events such as these. Thank you so very much. It was an interesting day. Thank you.
Good morning, colleagues. On behalf of the Mona Library, I just want to say thank you to Ms. Kasim and Ms. Davis. They came in the rain, and thank you for giving them somebody to talk to. And so we are offering 2 little tokens of our appreciation. And as Mrs. Warren said before, we can have something like this every day. Don't you agree?
Looking for my phone.
Hold on a second. I just want to say one last thing.